start again. So good evening to everyone. It's 6 o'clock and it's Wednesday evening, and welcome to those of you who have joined us for the webinar. This evening is a medical legal update, and it was originally conceived really in the context of the COVID-19 and what claims for compensation that might arise from the COVID-19 pandemic. And then a discussion about tort reform, which is undoubtedly needed in this jurisdiction. Very sadly, events have somewhat overtaken us, and the ransomware attack on the Health Service Executive and other healthcare institutions in Ireland really have brought this very much into focus. And so all of our fellows and members are finding themselves in serious difficulties in terms of dealing with patients and of necessity accessing the appropriate investigations and indeed recording of their findings. So it is a really appropriate subject to have for discussion this evening. I'm very grateful to Council Member Margaret O'Donnell, who is known to all of us, consultant plastic reconstructive surgeon and medical director of Blackrock Clinic, and past president of the Irish Association of Plastic Surgeons. Margaret has had a long interest in medical legal affairs and has worked with the Medical Protection Society in delivering some of their updates and education for the profession. I'll leave the introductions to Margaret, but we're very grateful to Dr. James Thorpe and Mr. Tom Hayes, who have joined us, and I'll leave the introductions to Margaret. Margaret.
How frustrating. Thank you. Thank you, President. And thank you for that introduction. And I think you've outlined what we're going to be talking about this evening so well. We had initially considered what were the issues in COVID times, and now we're faced with the cyber attack. So we are going to address all of that in totality. So I'm really pleased that we can welcome James Thorpe and Tom Hayes both this evening to this webinar, and both have immense knowledge and expertise, and I am assured will be able to answer pretty well any question that is put to them. And I think to really move on, because I think the question and answer session in this webinar in particular will be really, really useful. Please do send in questions by the chat box. We have had some in advance, and if you wish at the end to put your hand up and ask a question, that can be accommodated as well. But perhaps the chat box is the most useful. So we're going to have a format that James is going to do a presentation first. Then we're going to pause, and Tom Hayes is going to join him for the questions after that presentation. And then Tom will do his presentation and we'll have questions again at the end. I'd like to introduce both of them. James Thorpe is a doctor and a lawyer. He joined the Medical Protection as a medical legal consultant in 2014 and has a lot of experience assisting healthcare professionals in Ireland. Some of you may have even spoken to him on the phone. He helps doctors to reduce their risk through his work as an educator with the MPS. And the MPS is a large part about trying to prevent incidents happening as well as helping you deal with them. He has a degree in medical ethics and law and trained as a general and a vascular surgeon before moving into medical legal work. And he's a fellow of the Royal College of Surgeons of Edinburgh. So James, would you like to start sharing your screen? And we'd be really interested in your views. Thank you.
Thank you, Margaret, and thank you, Mr. President. I'll just get the screen sharing started. Okay, I can see it's just loading up on my screen. Hopefully you can all see the first slide there. That's great. So again, thank you for that introduction. Thank you to the college for inviting us to speak this evening on some of the current medical legal issues facing the profession. And initially, as has been alluded to. This presentation is mainly to do with COVID, but I think some of the things I'll be discussing are very relevant to the cyber attack as well. And I think that some of the medical legal issues that are faced by the profession in Ireland currently, some of them are issues that were already a problem but are being exacerbated by the pandemic. So I'm going to talk for about 15 to 20 minutes before handing over to my colleague, Tom Hayes. And I thought it'd be helpful to first highlight some of the current medical legal challenges facing the profession before looking at our experience at MPS with cases related to COVID-19, which are slowly starting to filter through. And I'll then briefly mention some of the other relevant medical legal considerations and potential issues, and reiterate top tips for helping you to try and reduce your medical legal risk. And following that, as has been mentioned, Tom and I would be delighted to hopefully answer any questions that you have.
Can I just interrupt you there? Just if anyone has their microphone on, could you just check it's turned off? We're just getting a bit of interference. Thanks.
Okay. Excellent. So, well, clearly the pandemic has caused or worsened many issues within the healthcare system, as well as introducing new ways of working, such as the absolutely huge increase in the use of telemedicine. So I thought it might be helpful to look at some of those issues in greater detail. Now, I suppose firstly, it goes without saying that this year has been absolutely horrendous for healthcare professionals around the world. And I saw it described quite succinctly as a year of extreme and unrelenting pressure. And I'm sure that all of you on this call can identify with that. And we certainly see that in our work with our members in Ireland, and also obviously with our contacts in our personal lives, fellow clinicians. Added to that is the cyber attack, and again, it's already been spoken about. I've seen that described as a crippling blow to a system which is already under immense pressure. And understandably, all clinicians, including our surgical audience tonight, are understandably concerned about the risk of complaints, about the risk of being referred to the medical council, about the risk of claims for compensation. And that might be due to delayed or missed diagnoses. And there can be lots of reasons for that. I mean, initially when I prepared this talk, I thought it might be patients not accessing services because they're concerned about COVID. It might be because investigations or treatment have been delayed due to COVID. It might be because screening programs have not been running due to COVID. But I suppose added to that, we now have the additional problem of the cyber attack and potentially patients not being followed up appropriately because of breakdown in communication, for example, between the GP and between the HSE, or between different specialties within the hospital. And a situation that was described to me just earlier today, you know, the fact that sometimes now chest x-rays, for example, are being looked at by a clinician, and then there's no way of storing that image. I mean, that, you know, from a medical legal perspective, is quite frightening, really, that there won't be a physical, or not even a physical, a digital copy of that image available in the future if the care is ever queried. So recent figures show that there are almost 900,000 patients on waiting lists from the HSE, with over 20,000 waiting over a year for essential hospital treatment. And it was reported in the media this week that, speaking on behalf of the IHCA, Professor Seamus O'Reilly of Cork University Hospital, an oncologist, has warned that delays could increase cancer mortality for the next decade, and highlighted that 60% of referrals for colonoscopy are waiting over 3 months. So I think all of those issues are clearly quite alarming, and there's really no sugarcoating this raw data. And there clearly is a significant risk of increased medical legal actions and dissatisfied patients due to all of this. But I suppose added to this backlog, there's also an issue surrounding the resources available to deal with it. Some of you, I'm sure, have seen this document. The HSE have published their Safe Return to Health Services plan, setting out a three-phased return towards normality. However, resourcing was clearly an issue before the pandemic, and again, the problems have been exacerbated. So there's a reduced capacity to deal with elective patients in both an inpatient and outpatient setting. There are many reasons for this, but there's likely to be a requirement for social distancing and enhanced hygiene measures for the foreseeable future. And the IMO have highlighted that there are currently, I think, 728 vacant consultant posts across the HSE, with 1 in 5 oncology consultant posts unfilled. Added to that, you've got the reduced staffing availability due to staff absence. Long COVID is an issue for staffing. There's also staff that have potentially been redeployed either to do the vaccinations or to other specialties. So there are really numerous challenges. And again, I can't provide any false reassurance here. These are issues that are out with the control of you as individual surgeons, but they do inherently make the practice of medicine potentially more risky. So in terms of how you can reduce that risk, and I think one of the messages I think that I'll be trying to get across is really, it comes back to the fundamentals of good practice, really. And I know, and we completely emphasise with the awful position that the profession in Ireland are in currently with respect to documentation, but meticulous documentation is always important, unfortunately, in a medical legal setting. So if a patient's follow-up has been delayed due to COVID, particularly if that was out with your control, it's important to include that fact in your records or in the clinic letter. And I suppose the same is true if the cyber attack has impacted on a patient's treatment. It's very important that when you do have the opportunity to document, that you carefully make sure that you note that in the records. I think, you know, if there's a specific situation as well where you're wondering what the best thing to do is, remember you can contact us at Medical Protection or your own defence organisation and ask for specific advice about what you should do in a particular challenging situation. But overall, I think documentation in some format is required, even if that means going back to a pen and paper and storing that securely within the hospital until a time where electronic systems are back online. I think one of the things that we always like to point out is that often a claim or even a complaint, I've seen complaints to the Medical Council submitted about care that took place 20 years ago. So if a claim or complaint is submitted with that sort of timescale, you may not remember the exact sequence of events. And from my own experience, it can be very difficult to go back and look at hospital administration systems, for example, to work out what happened in terms of appointments or why procedures were delayed. And presumably that will be even more the case potentially following the cyber attack. So your own records or the patient's records within the HSE hospital are really important. The other thing, obviously we've talked a lot about resourcing, and the Medical Council do make it clear in their ethical guides that you must raise concerns if you have concerns about the systems or service structures in place, if you think that's going to lead to a risk to yourself or to patients or to colleagues. And if you do feel that you're at a stage where you have to do that, we're happy to offer advice, but usually you would need to do that in writing so that there's a record of the concerns that you've raised. Okay, so the next area I wanted to touch briefly on is telemedicine, and in particular remote consultations with patients over the telephone or video. And as part of my role in the risk prevention department at Medical Protection, I've been involved in a series of 4 webinars on telemedicine. And we had a webinar, I think just 2 weeks ago, where we did a poll of almost 1,000 members joining the webinar. And that demonstrated that over 30% of the audience were doing between 75% and 99% of their consultations remotely. And this is clearly an absolutely huge increase compared to pre-pandemic times. Now, there is some research showing that remote consultations do not seem to be inherently more risky than face-to-face consultations, particularly for patients with chronic conditions or low-risk patients. But as I've included on the slide here, a recent NPS survey of 361 doctors in Ireland demonstrated that a large majority are worried about missing something during a remote consultation, and that the increase in remote consultations may cause patients harm. Now, lots of considerations when we think about teleconsultations, and if you're an MPS member, I thoroughly recommend our webinar series, which is available to watch back on our e-learning platform, Prism. However, again, in terms of reducing your medical legal risk as a surgeon, I think there are some key points that I can bring out tonight. And I think the first is that you consider the basics, the same things that you would think about when you're doing a face-to-face consultation. So consent, and that's in the context of a teleconsultation, a consent to proceed with a remote consultation. Confidentiality, being aware of who else is in the room with the patient and who else is in the room with you. And effective communication, and that can be more difficult over the telephone or via a video, so you have to pay a special attention to that. I think secondly, if you conclude that a patient needs to be seen face-to-face for the interaction to be safe, then this should be facilitated. And the most obvious reason from a surgical perspective is if they need a physical examination that can't be done over video, but it might also include things like taking consent for a procedure. I mean, if you feel it is necessary to draw diagrams or display images in order to explain the surgery to the patient, then this should be done. And if that has to be done face-to-face, then that's how it should be done. Hopefully with increases in improvements in technology, there may be facilities for sharing documents, but that can potentially need quite a lot of IT literacy, which might not be something that all patients have. So I think there are lots of considerations specific to surgery when it comes to teleconsulting. And again, documentation is really important. You should write down that the patient has been seen remotely and the reasons why. And if you feel that the patient needs to be coming to be seen face-to-face and they refuse for one reason or another, despite an explanation as to why that's necessary, write that down too. Because I can't emphasize enough, and I'm sure Tom will agree, that good records will help whoever is defending you in any complaint to the medical council or claim for compensation. I also want to touch on burnout, and I'm sure that the current awful situation in the hospitals is not improving these statistics. Now, again, burnout was an issue even before the COVID-19 pandemic, and at NPS we've done quite a lot of work on burnout, and we run a face-to-face workshop on burnout. But a recent IMO survey highlighted the sheer level of the problem amongst the profession in Ireland. And although it's somewhat reassuring that 80% of the doctors surveyed said they still had a strong desire to practice medicine, 90% stated that they suffered from some form of depression, anxiety, or stress made worse by their work. And I think this is reflected also in the practitioner health programme, who noted a 50% increase in demand for their services compared to the same period last year. Now, again, there is a lot of evidence to show that doctors suffering from burnout are likely to receive more complaints, and therefore this is another area that needs to be addressed in order to reduce the medical risks or the medical legal risks enhanced by the pandemic. So moving on to what we've seen so far at MPS, and again, harking back to the cyber attack, we've actually had very few calls regarding the cyber attacks so far. I'm sure that we will start to see more coming through. But in terms of the COVID pandemic, we haven't seen many claims related to COVID so far. I actually just checked today after I've written this slide, and one of my colleagues in the claims team explained that they've had one claim in Ireland related to COVID with an allegation that a patient should have been seen face to face rather than remotely. But we haven't seen the claims filtering through the system yet. But as you may be aware, the statute of limitations in Ireland, so the time that a patient can make a claim is 2 years from the date that the patient is harmed or becomes aware that they have been harmed. So the clock is still ticking, as it were. And Tom, I'm sure, may also pick up on this, but it does seem inevitable that there will be claims relating to delayed or missed diagnoses. It's just that we haven't seen them yet. What we have seen is numerous requests for advice on COVID-related issues, and we provide advice on all aspects of legal and ethical issues arising from the practice of medicine. So we've seen lots of queries about vaccines and the delivery of vaccines, especially, I suppose that's more from our primary care GP colleagues. Lots of queries about various issues to do with telemedicine, all sorts of issues that you can think of, that come up with telemedicine, things like chaperones, how do you examine potentially intimate areas, how do you store consultations, what about recording consultations. So there's all sorts of issues which we had lots of queries about. And we've also had lots of queries from doctors who've been asked to work outside of their usual area of expertise. In both Ireland and the UK, we've also started to see quite a few complaints coming through, and I think in the initial phases of the pandemic, there was a sort of sense that everybody was in it together, but we have unfortunately started to see more complaints against the profession. And there are often complaints about delays in treatment, investigations, or a perception that the outcome for the patient would have been better if they'd been seen face to face rather than remotely, with GP services especially tending to move almost entirely online. And I've no doubt that similar complaints will filter through to the Medical Council in due course. Now, one thing I think that's important to highlight is the Medical Council have made it clear that the context of the pandemic will be taken into account in any complaints they receive. And they have also recently made a similar statement in relation to the cyber attack. We've also seen a few requests for assistance from members for inquests, obviously when a patient has died, and it's alleged by the family that the patient's death could potentially have been avoided, for example, if the patient had been seen face to face rather than remotely. So that's some of the types of cases that we're starting to see coming through. I also thought it'd be helpful just to do a little bit of horizon scanning and just mention a few other relevant considerations in the medical legal landscape. And we've already mentioned it, the impact. Sorry, somebody muted me. I'm not sure how that happened, but somebody muted me briefly, but hopefully you can all hear me again now.
Yes, we can. Yeah.
So firstly, the impact of the cyber attack really is still evolving, with services still significantly impacted, and as I mentioned already, potential risks in terms of continuity of care. We're aware of all the problems that are happening with clinicians having to look at scans, for example, on poor quality screens, and again, this is clearly a significant ongoing risk. Mandatory open disclosure, the Patient Safety Bill, it was originally the Patient Safety Bill 2018, I think, and then it changed to the Patient Safety Bill 2019, but it's still not got through the final stages at the committee stage in the Parliament. So it's still going through, but it's likely to come into effect later this year. There's been some recent coverage on that, and that effectively mandates open disclosure of serious patient safety incidents. And in the current iteration, it still suggests that there should be a criminal sanction if mandatory open disclosure is not made in the way of a fine. But I'm sure there'll be more to say on that as the final details of the legislation are clarified. Other issues that could be relevant from a medical legal perspective include potential de-skilling of surgeons and others in procedural specialties, and I think it's an interesting thing to think about. At what stage will a claimant solicitor make the argument that an individual needs retraining or mentoring because they haven't been doing a particular procedure due to the pandemic? There are also obvious issues, I'm sure, as amongst your own colleagues, you've discussed this, but there's obviously issues with training of juniors, and presumably ensuring they have enough experience to practice safely as a consultant, because if they are not adequately prepared, obviously that increases medical legal risk. I also think there's issues for elective surgery, especially outside of, I suppose, life-saving cancer surgery, and testing or vaccination of patients preoperatively. Given that there's very poor outcomes for patients who undergo an elective procedure and are later shown to be suffering from COVID. And I suppose that's something that needs to be covered in consent, given that there is an incubation period for symptomatic infection, and there's a potential risk of a patient testing negative preoperatively, but subsequently testing positive. So that is, I suppose, an issue that needs to be considered. The Medical Council also has, I suspect, has a significant backlog of cases. So that's another thing that's on our radar, that a case that's referred to the Medical Council now, there might be a significant delay before that's dealt with, should it proceed to a fitness to practice inquiry, with the sort of ensuing stress for the doctor and the other individuals involved. So lastly, and before we answer some questions, I'm going to try and keep this fairly brief. I'll just go through some top tips. But I think the foundations of high quality care haven't really changed, despite some of the enormous challenges which are out with your control as individuals. I know I've already mentioned it, but I don't want to labour the point, but documentation is fundamental for mounting a defence to a complaint to the Medical Council or a claim in negligence. And secondly, I think choosing the appropriate mode of consulting with your patient involves clinical judgment. And if you can't safely assess them, you may need to see them face to face. And lastly, I think optimizing communication with patients and with your colleagues will help to reduce the risk of complaints and claims. And as you all know, medicine is inherently risky and things will go wrong. There are recognized complications of procedures, but that is still an adverse outcome for the patient. But the research really clearly shows us that when things do go wrong, doctors who communicate well with their patients are less likely to receive a complaint. Okay, so I think I'll stop the screen share now, and we'll take some questions.
Can you hear me?
Yes, we can hear you.
That's fine. Sorry, I could hear an echo. I would like to welcome, and Tom Hayes has come back on screen there to join in the questions at this stage. Tom is a solicitor who spent the majority of his time in private practice with over 25 years of experience in medical law and malpractice, defending medical practitioners in relation to claims for compensation, that's in the civil situation, and also their professionalism in the medical counsel and statutory inquiries. Tom was a partner in Matheson's and was head of healthcare law there, and is now head of delivery services with the medical protection in Ireland. So has a wealth of experience. So
thank you, Margaret.
Has anybody, you're welcome, Tom. Has anybody any questions they would like to pose first to either James or Tom or together? We'll maybe spend about 10 minutes on questions now, and then Tom would give his presentation. President, have you a question or comment?
No, I would just like to thank James. I thought it was very interesting that your slide that showed a mesh being put in at the same on the surgical thing was very appropriate for a medical legal presentation, but that was just an aside. I thought your presentation was very measured, very helpful. I guess all of us just need to take to heart the fundamental principles of good communication and, where possible, record, and where you're working in adverse circumstances to document that. I mean, and we've been all too familiar with this, the situation where there's somebody in the emergency department and you're caught in theatre and there's been a delay of hours while you're dealing with the problem, and of course the outcomes aren't as good as they should have been, and somebody looks at it, and unless it's documented what the situation was, and that you found yourself in a situation where you simply couldn't be two places at the one time, then it looks bad. So yes, documentation. The question I have is if there isn't a system, for example, my wife works in a newborn intensive care unit, and they can't print out patient labels and things like that. I mean, it's really down to a level that nobody has experience of in terms of paper management, unlike in the 1970s and 80s where that was the norm. I mean, labels were a revolution. I don't know what advice we can give to people except they must do their best.
I think that's right, and I suppose that there's a couple of things. I mean, I suppose the HSE in a. I'm back. Sorry about that. I got a message saying I've been kicked out, but I'm back. But on you go, Tom, in case I get kicked out again.
I was just trying to predict what you're going to say, but we haven't rehearsed this. But in the context of the HSE, and to pick up on your example, Mr. President, I think, you know, if I was contacted for advice about that, I'd be registering that concern with my employer, indicating that there is a significant risk in my inability to print the label. Ask the employer, you know, what's the solution? What can we do in this circumstance? If there isn't one provided by the hospital, then as you say, it's just doing your best. It's doing your best, making a note of that fact, registering that, and certainly noting that concern, particularly in circumstances where it affects the quality of care you're giving to a patient, and indeed your interactions with your colleagues as well.
And if I could just come back on that, I mean, is there a role for keeping a personal log or a personal diary of these? Because in the absence of a system that is prepared to cope with paper having gone electronic, should one keep a personal diary and with maybe hospital numbers rather than patient details?
I think. Sorry, Tom, I'll just maybe come in there. But I think, Mr. President, I think one thing, what I would say is that I think that is a reasonable thing to do, but you have to be very careful in terms of GDPR and in terms of data protection. You know, there is a potential there. I certainly wouldn't recommend that any list, even if it's just hospital numbers rather than names. I don't think it should be taken home and stored at home. It's the type of thing that needs to be stored securely within the hospital. There's no easy solution, and I'm sure we've all seen examples of books with patient details that used to be kept in offices and wards, you know, for example, for referrals and so on. And again, that's not ideal if they're in publicly accessible areas. But I think these are the sorts of things that, you know, defence organisations can provide some advice on. But ultimately, the ultimate responsibility for data protection within the HSE falls to the HSE, and they should really have policies and procedures about what is acceptable. And I mean, it's almost like I think Tom mentioned earlier, it's almost like a wartime footing, and really they have to come up with innovative solutions to try and deal with some of these issues.
Thanks, James. A couple of questions have come in. One came in earlier about expert witnesses. And at the best of times, people sometimes are frustrated by an expert witness on the patient plaintiff side, where that witness is either a different specialty or from a different jurisdiction or working in different environments. But now with COVID and with the cyber attack, obviously that's a huge mix, and that you may have an expert witness who has not been working in the same COVID situation or environment. Some hospitals, some areas are more protected than others. And certainly with the cyber attack, some hospitals have been less affected than others. So what happens if we roll forwards a couple of years and there's a case where there's an expert who is working along the old way, if you like, working in old money? What reassurance can you give doctors that their expert witness would be listened to?
No, I think that's a good point, and you know, I've seen over recent years that the medical council, for example, has a tendency now to engage experts from overseas. So we're seeing English experts giving evidence before the medical council, and also in claims in the High Court. A lot of plaintiff solicitors have a tendency to go overseas, go to England and Wales for their expert reports. And you know, if that was to arise in future, and a practitioner finds himself in court or before a committee, you know, the point is actually made in the question that an expert who's giving evidence who works in this jurisdiction currently, for example, understands the context in which the claim arose and the particular issues around resourcing, for example, and demands on the service, that evidence is going to be far more cogent than an expert who's giving evidence from another jurisdiction. So I think, you know, in those circumstances, the defence team would have an edge. And it's an obvious point that, you know, a defence barrister with their solicitors in support would be making. Okay.
Thank you. Another question, and then perhaps we'd move on to Tom, your own presentation. This question may be more for James, but either of you maybe take it. A questioner says, it has been said that good communication decreases the risk of being sued. What is the evidence for this, as it hasn't been my experience, says the questioner.
Okay, well, there is.
Where do we want to start?
I haven't got the references to hand, but you know, a lot of our face-to-face, and Margaret obviously has been involved in many of our workshops and so on, and there has been significant evidence from multiple jurisdictions that good communication and being open and honest with patients can reduce the risk of complaints or claims. And unfortunately, I know it doesn't always feel like that, and certainly, you know, I did a webinar on telemedicine just the other day, and where one of our members commented, and it wasn't really a question, it was more of a comment, saying that one of the things we would usually recommend in telemedicine is that you ask the patient what they are expecting to get out of the consultation. And this member commented that he had done that and received a complaint that he'd asked them about what they thought should be done. So you can't win sometimes, but in general terms, there is good evidence that communicating well with your patients can reduce the risk of complaints and claims. I mean, it stands to reason that if a patient is happy with how you're dealing with them, they're less likely to complain about you.
Yeah, and I think there is a huge amount of evidence and a lot of research showing that, and the emphasis on good communication. I think it's sometimes hard to know what is good communication, and this is where the webinars and the workshops and practicing these things can be very helpful, because there is a structure in how to deal with an adverse outcome and how to go about the conversation with the patient. And there are very learned writers and authors who would say that the problem that arises is one issue, but it's the discussion afterwards that really compounds the problem. And so you can make a bad situation worse, or you can retrieve it depending on how that conversation goes. Tom, I'd like you to take off, if you wouldn't mind, on your presentation. Can you share your screen, or to James, are you sharing it for him?
To do that now, yeah.
And then we'll have time for a few more questions coming towards the end. Or like Samantha, Sam, do you want to share it?
No, it's all right. I think I'm there now. Yeah.
Okay, perfect.
That should be loading up.
Super. There was a comment about, isn't the employer the liable one under such circumstances on the basis of vicarious liability? That's in terms of the question earlier, but we'll bring that to the end maybe, because it probably ties in with some of what you'd say. Thanks, Tom.
Can you see that now, Margaret?
Yep, we're seeing the first slide. Thanks.
Right, so just picking up on Mr. President's comments at the beginning of the meeting, I was planning to talk to you about tort reform, and the need for reform in the context of most recent events is even greater, as James has been alluding to. So I'd like to take you back now to 2007. That's when I arrived in the country from London. I've been practicing in London for about 8 years before I arrived here about 14 years ago, and joined Matheson, as Margaret alluded to set up the healthcare practice group there. And things were pretty quiet, really. There wasn't an awful lot going on in the medical malpractice space. But of course, within a year or so, we had the economic crisis. And what we saw from then on was an exponential increase in claims and complaints against medical practitioners in Ireland. And I became incredibly busy with that sort of work. So one would think, well, there is a link, obviously, between financial economic contraction, and I think there was a contraction back then of about, I was reading about it the other day, of about 15% in the economy. And a lot of lawyers who would have traditionally worked in the area, perhaps assisted businesses and corporates and other areas of work, that work dried up for them. And they became available and interested in personal injury litigation and medical malpractice litigation, and there's general growth in litigation in any event. So fast forward to pre-pandemic, things were very busy as well. There was a bit of a lull around 2017. Things got a little bit quieter in Ireland for litigation. You probably wouldn't have felt it, but they did. That's what the statistics show us. But then there was another jump around 18, 19. There was another jump in claims incidents in Ireland against doctors. And now that since the pandemic has hit, we have been increasingly concerned that we have two issues. We have a healthcare crisis. We've had a suspension of services in certain areas, a very abrupt suspension in certain circumstances, and a general suspension, for example, in areas of diagnostics, and issues arising between communication between the primary sector and secondary care, hospital sector. But on top of all of that, now we've had a financial crisis. We've had the economy's been hit, and now we have this cyber attack. So rather depressingly, we are concerned that we will see an increase in claims and complaints. It may not be imminent, but we may see the impact of this in 2 to 3 years' time. So I'm talking to you about tort law, and I thought it'd be worth, just in case any of you out there are wondering what is tort law. Well, it's not criminal law, it's any civil wrong. And in the context of your work, what does that mean? Well, if you're considered to injure or harm anyone, you can be liable in law to compensate them. And what does my liability mean? Well, quite briefly, a plaintiff, a patient who wants to bring a claim against a medical practitioner, has to demonstrate that the practitioner owes them a duty of care. And in the context of the law in Ireland, that's really a given in the majority of circumstances. And one has to demonstrate as a patient that there's been a breach of that duty of care. So you're responsible for some act or omission that no ordinary practitioner exercising an appropriate standard of care would have committed, and that you have caused harm as a result of that breach of duty. Now, and that's called causation, that causation of harm. If you can demonstrate both of those elements, a breach of duty and causation, they're a bit like peas in a pod, then the patient will be successful in achieving compensation in court. Without those two peas in a pod, then the plaintiff won't succeed. So we have seen examples where perhaps there's been a breach of the standard of care in a case, but the patient can't prove that that has actually caused the harm that they complain of. And if they can't do that, then there can be no compensation. So that's it in a nutshell. There's obviously a lot more to it, but in the time I've got allowed, that's a good summation of the law of tort. And what does that mean? We've probably heard and read about damages. In Ireland, a patient can be successful in receiving compensation for pain and suffering, loss of amenity. So, for example, if they've injured their leg and they have a permanent injury, and previous to that injury they like to play golf and they can no longer do that, they can claim damages for the pain and suffering that has resulted from any medical malpractice, and the loss of enjoyment of life, if you like, their inability to enjoy the things that they used to before the injury occurred. A significant component for us in damages is the plaintiff's ability to pick up compensation for loss of earning capacity. So, for example, if you have a plaintiff who, worst case example, was a professional footballer before they're injured and can no longer work, so they're young and they're a high earner, you'd be responsible, the defendant doctor would be responsible to compensate that plaintiff for their loss of income as a result of any injury. And it's quite common as well for another head of damage might be any sort of expenditure or costs that result from the injury. And again, if that's an ongoing cost for the rest of that patient's life, then the defendant has a responsibility to compensate for that. In catastrophic cases, of course, where, for example, a patient has been injured, has brain damage, is incapacitated, needs constant care, those claims can run into the millions, because that particular patient may require ongoing 24-hour care for the rest of their lives. And if they're young, those awards can be very, very high. And we've seen those sorts of headlines recently where you have some plaintiffs compensated into the millions, as much as 20 or 25 million. Most of that is to do with future care costs. Okay, so what are the problems in Ireland? Well, I could speak for another hour on this, and I'm conscious of the time, but litigation here is slow. it's expensive. Many complain that it's unfair, and you might think, well, okay, why is that? Well, it's there are many reasons for that. It's not fit for purpose. We don't have something called case management in Ireland, which I'll go on to talk about in a minute, which you see in other jurisdictions. The system is overburdened. Going back to the points I made earlier, Irish practice and procedure hasn't changed really for an awful long time. The general principles in relation to the administration of justice for these sorts of cases hasn't altered for a significant amount of time. The system is overburdened. It's under-resourced, and we saw President of the High Court, Mary Irvine, recently saying that we needed 20 more judges needed to be recruited into the court system just to cope with present workloads. And because of that, it moves slowly. The costs of litigation have grown exponentially over the years. So we've seen increasing costs. And what I mean by that, well, legal costs. The damages that are awarded here in Ireland are much higher. So I mentioned that I practiced in London for 8 years before I arrived here 14 years ago. And in London, and it's the same, you know, nothing's changed. I'd be reserving something here in Ireland when I arrived at 3 to 4 times as high. So, you know, when we're putting an estimate of where we think how much a claim is worth, three times as much as I would have done practicing in the UK. So awards are higher here. That means settlements are higher, legal costs are higher, and that impacts on the costs of doing business in this country. So out of the 10 countries that MPS currently indemnifies in jurisdictions, Ireland is the most expensive jurisdiction to do business in. And obviously that impacts on subscriptions, because we have to ensure that we are covering the risk of those claims going forward. I've mentioned about the economic considerations already, and just in the context of another theory as to why people are more entitled or are more likely to sue over the last 15 to 20 years, is growing, you know, this consumer expectation that everything's going to be fine in the context of the care that's provided. It's growing consumer expectations regarding a number of other sectors, but healthcare is in the middle of that as well. So having a look, you know, just looking at globally, having a look at what's happened in other countries on this issue of reform. Well, the Australians were leaders in this. So, you know, my career started off in Australia in the mid-90s, and back then the Australians were way ahead of the game. You know, they were already concerned about the rising costs of litigation, the rising costs of awards, and in fact their whole insurance system nearly went into meltdown as a result of the level of awards that judges were making at the time and the inability of some insurers to provide for them. So they, as a matter of necessity, because they were concerned about practitioners not being able to have indemnity, changed the whole system, put caps on damages, strongly case managed their cases to ensure that things are resolved quickly. So they were always leaders in the field and gave, you know, ensure that there was real change. In New Zealand, of course, we have no fault compensation. So the incredibly radical approach to medical malpractice claims. And, you know, as a result, patient doesn't need to prove breach of duty in relation to a case, still has to prove causation, but the level of damages and the speed at which things are resolved in New Zealand are far quicker. In England and Wales and Northern Ireland, we have case management. So cases are project managed by the courts. That means that cases are resolved far more quickly. So if a defence solicitor has to front up to court with a plaintiff solicitor and agree a timeline for resolution, agree steps for exchange of factual evidence, expert reports, and importantly, experts meetings, which are key to early resolution of cases. And as a result, cases resolve far quicker in England and Wales and Northern Ireland than they would do than here. They also have something called pre-action protocols, which means that, quite simply, the parties have an opportunity to resolve their differences before they resort to going to court. There is a system, a protocol around the resolution of cases before they start. And just looking at MPS's own stats, up to 70% of potential claims can resolve in this way by, for example, the plaintiff setting out in writing what their claim is based on expert evidence and the records, and then the defence team responding in 3 months before they ever go to court. And what that means is the parties can resolve things quickly and early before they ever get to the door of the court and issuing proceedings. The US has reformed itself, but here in Ireland, really, and sadly, things haven't changed that much at all. We don't have pre-action protocols. We don't have case management. And because of that, we have a lot of litigation. And if you look back at what MPS has done over the last 15 years, it's done all the right things. It's had town hall meetings, it's released papers. We've had various conferences where we've called for reform. During that time, the state has commissioned itself 2 expert working party groups, one chaired by the President of the High Court herself, Mary Irvine, back in 2010. The recommendations of that report, which took a couple of years to compile, were, yes, you guessed it, pre-action protocols and case management. Then Judge Charles Meenan was asked to do the same thing back in around 2018. He reported at the end of 2020. Within his 17 recommendations, the principal recommendations were pre-action protocols and case management. In the middle of all that, in 2015, we've actually had legislation passed that provides for pre-action protocols, but it hasn't been enacted yet. So I'm determined to actually push this on. I think, MPS, we want to really find out what the blockages are so we can get this over the line, because I think it will have a significant impact in reducing the stress for doctors, ensuring those patients that are wrongly injured are compensated much earlier than they are at the moment. And it will be good for society because as taxpayers, we all pay for this. We pay for these delays and the increased costs of doing business here. So that's all, Margaret, I think I wanted to say. I can see it's coming up to 7 o'clock, so.
Thank you, Tom. That was really clear, very concise, and really distilled an enormous topic into a message that we can all easily understand, and can hear your frustration with this pre-action protocols and case management. We are allowed to have a few minutes for questions if people are willing to stay online. One comment has come in about the views of the clinical indemnity scheme, and I think while you both would be speaking with an MPS hat on, I think everything you're saying is also, could I say, the views of the clinical indemnity scheme, that their ethos and view on this would be largely in keeping with what you're saying. I think the legal practitioners in this aspect and the claims management aspect, you would be on very similar ground.
Yeah, well, I think, I am planning to meet with Kieran Breen to discuss their approach, but I know in the context of pre-action protocols in the past, they have been supportive. But we have a blockage, and I think, it's important that we go through a period now of consultation, talking to key stakeholders, getting their views to work out, why it hasn't happened. And I think just doing everything that we've done before is not the way to go about it. So, we are keen to get this moving, but, it may not necessarily us be that are seen to be banging the drum on this. We need to be strategic to ensure we get this over the line. So that process has started. We're talking to key stakeholders in the marketplace, and of course, Kieran Bean is a really important player in this. The State Claims Agency is responsible for taking on so much risk in Ireland that we need to be on the same page in all of this.
Yeah. And obviously they take on the risk over and above where the caps come in as well. So they have a definite interest in this. And I think interesting to see the different countries and how far they are ahead. It seems such a simple thing that this would all be project managed, and the frustration that the doctors find when a case goes on and on and on is only magnified, I'm sure, from the patient side of it when it's going on and on and on. So at a simple level, project management would be wonderful, I'm sure. Sorry, Ronan, President, you have your hand up.
Well, thank you, and thank you to both our speakers and Tom. That's extremely interesting. I'm not sure many of us knew that legislation had been passed but not enacted, and as I understand it, that just requires ministerial order.
That's right. That's right, and I think just looking at the new Justice Minister's plan for justice for the year, she's very much in favour of reducing the amount of time that cases take and minimising the costs of litigation. So again, you know, one would hope that it doesn't really require that much effort to get this done. But that legislation has been sitting there for the best part, you know, since 2015. It just needs
it's not the medical profession, and it's almost certainly not I suppose the legal profession must be the holdup. It's not the judges. It must be the legal profession that are looking to stymie this.
Well, I mean, there's no doubt that lawyers have benefited greatly from the increase in litigation over the years, and I think, you know, the Law Society has come out relatively recently and said it's very much in favour of pre-action protocols as well. So everyone seems to be on the same page, and you know, in the context of getting this done, I think case management perhaps is harder because it requires more investment. It requires more judges, more masters to get things done. But, you know, it goes on in the commercial courts here in Ireland. Case management is a very strong and works extremely well. It just hasn't been implemented here. So from pre-action protocols, Mr. President, I cannot see why they haven't happened. I just don't want to go on a campaign in that regard until we truly understand what the blockages are. And I think by this engagement, by meeting key stakeholders, we'll find out.
Thank you.
Okay, there's a hand up in the audience and I can't see.
It's Peter O'Rourke.
Peter, do you want to have a quick question before we wind up?
Need to unmute yourself. Yeah.
Yeah. I've recently retired as an orthopedic surgeon. So in the course of my career, I was sued a number of times, and I had suggestion that I was being sued a number of times. One of the issues I've always had is I have never, ever received any feedback from our insurance service, not the MPS, I know I might add, as to what the outcome of any of these cases have ever been. They just seem to go away, and nobody ever bothers to tell you what has actually happened, if it's been dismissed, if it's been settled, and unless it is going to court, then you might hear about it. But other than that, there is absolutely no feedback.
Would either of you address that? I think it's a big frustration, and frustration when we could all learn from these things. If there was even if people were anonymized, cases were anonymized. But I think out of courtesy, the doctor who goes through a huge amount of stress in these cases should be told the case is completed or finished or closed.
No, I'd absolutely agree with that, Margaret. And in the context, for so many reasons, I appreciate that perhaps in the context of the situations you're talking about, it's the HSE or another organisation that's been sued, but it's very important that one knows what's happened when a case has been commenced, how it's been resolved, and as you say, whether there's been any lessons learned for the organisation as a result of what's happened. And
I think one of the frustrating things is we keep hearing that we're being reassured, doctors get told that 97% of cases get settled before they go to court. So doctors aren't to worry because there's only 3% go to court. But that would suggest that there's a lot of 95, 97% of cases that we don't know what happens with it. Doctors find it difficult to know how they would change practice or improve practice. And it's not certain, I mean, maybe the knowledge is with the MPS or the clinic indemnity scheme, but that's a big number to not know about as to what's happening. I think
there's one more from Liam Joyce, Margaret.
Okay, Liam, hi. Do you want to have a question?
Yes, can you hear me there?
We can indeed, thank you.
Yeah, very interesting, fascinating talk this evening. Well, I was a member of the MPS for many years, and I'm just curious about Tom and James there. There's no policy document at all regarding your membership on what you're insured for. And also, the MPS is a discretionary organisation. It doesn't have to respond or defend a claim if it doesn't like the claim. Is that true?
Perhaps I could take that one, Tom.
Yeah.
And I think discretion is something we are asked about fairly regularly. And as a member-owned organisation, really our default position is to see how we can help, and a discretionary approach enables us to respond quite quickly to developments in the medical legal environment. So I suppose assessing claims and complaints against emerging issues and risks, and treating each case on their individual merits. And it does mean that we can assist members with issues that might not have been foreseen at the time membership was taken out, which might not be the case with an insurance product. I think that's what I would say on discretion.
And I think to make it clear, I think the MPS isn't an insurance company, it's a mutual organisation. Would either of you just expand on that as to the difference? But that maybe ties in with the discretionary.
Yeah. Well, I think, as compared to insurance, there is, if one is, just from my experience of acting for insurers in the past in the context of medical malpractice, first thing you're asked to do is to consider whether the claim that's made falls within the conditions of cover. It's a contract. It's a contractual relationship between practitioner or the organisation and the insurer. That's not the case with indemnity. So that particular contract, like any contract, will spell out certain conditions of cover, just like you would do, for your car insurance or holiday insurance. It will have conditions. That's not the case with discretionary indemnity.
Okay. I think we could honestly, probably take questions all night, but I know we have a time limit, and I'm sorry if we haven't got to some of the questions that have come in about telephones and all the practical issues. But I think you've both been very honest and very clear and very helpful to us all, I think, to hear what you've had to say. And I hope it's been somewhat reassuring that if we do good practice and keep our documents and do our good communication with the patients, that is ultimately what we're about, but that also is our protection in any of these difficult situations. If the President or Vice President want to add anything.
Thank you, Margaret. Thank you, Tom and James, both. Very interesting, reassuring, helpful. I had occasion recently clearing things out to find my receipt from 1979, where I was insured for £10 for the year, and I had an offer of lifetime membership for £100, but I couldn't afford it. But I do have the receipt for the tenner. So there you are. MPS has been very supportive of me. Fortunately, I've never ended up in the courts, but I've always found any recourse I've had to MPS very professional and very supportive, particularly of me as a practitioner, and I'm sure all of our listeners will echo that. And we thank you for your hard work on our behalves. As a mutual body, we feel part of the membership. So thank you all, and thank you, Margaret, for organising it, and thank you all for attending this evening, and we will look forward to seeing you next week.
Okay, good night, everybody.
Thank you.
Thank you both.
Thank you. Thanks.
Good night.
Thanks.